Coming to you from the Forge of Freedom studio in the heart of America. A podcast dedicated to preserving freedom and inspiring personal success. Freedom is born and lives through you, the individual, and it dies in the shadows of tyranny. Motivating our listeners to become well-rounded, freedom-minded people with the body of an athlete, the mind of a stoic, and the spirit of a warrior. The tree of liberty lives on through you, the Forge of Freedom. And now here's your host, Alex Ooley.
Hello, everyone, and welcome to the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 31 of the Forge of Freedom. This is just going to be a quick sort of bonus episode. I just wanted to provide a quick update with respect to the ATF Final Rule on pistol stabilizing braces. So we did an episode, my father and I did an episode, a couple episodes actually, on the ATF Final Rule on pistol stabilizing braces before the amnesty period ended May 31st. So for those of you who don't know, the ATF has for over a decade said that if you had a firearm equipped with a barrel that was less than 16 inches and it had a pistol stabilizing brace rather than a rifle stock, it was considered a pistol rather than a short-barreled rifle and did not have to be registered as an NFA item. Well, that remained the ATF's guidance for, like I said, over a decade until earlier this year in January when the final rule, ATF passed a final rule that brought these firearms under the purview of the NFA and required them to be registered and a tax to be paid. There was an amnesty period from January until May 31st, in which if you registered your firearm equipped with a pistol stabilizing brace, you would not have to pay the $200 tax. Of course, I don't think the ATF had the authority to promulgate this rule, or they do have rulemaking authority, but not this type of rule for lots of reasons. But they also, I don't think, had the authority to waive a tax. Nevertheless, they took it upon themselves to say that they could waive the tax. So nevertheless, people had the option of registering these arms up until May 31st without the burden of paying a $200 tax. During that amnesty period, several gun rights organizations, the Second Amendment Foundation, the Firearms Policy Coalition, and Gun Owners of America had legal challenges pending in the Fifth Circuit Court of Appeals, which is the federal circuit court, which is the intermediate appellate court in the federal court system, in the Fifth Circuit, which is Texas, Mississippi, and Louisiana. The first news out of those cases was in Mock v. Garland, which was the Firearms Policy Coalition case. And the judge in the Fifth Circuit issued an injunction, but that injunction wasn't clear. It wasn't clear who the injunction applied to. And the injunction, for those who don't know, just means that it stops the ATF or the federal government from enforcing the ATF's new rule while the case is pending, because the court believes that the plaintiffs are substantially likely to prevail on the merits of the case once the case is fully litigated, and they would suffer irreparable harm if the rule were allowed to go into effect. So, because of this ambiguous injunction, we didn't know who exactly the injunction applied to, who would be protected by the injunction. The Firearms Policy Coalition asked for clarification. And the court issued an order clarifying their injunction by saying, and I'm reading from the order here, instead, let me back up. It says there, the appellants, here the plaintiffs, the appellants, acknowledge that although a nationwide injunction would have functionally addressed the question of scope on which plaintiffs now seek clarity, plaintiffs understand that one was not given. Instead, plaintiffs merely request clarification on whether their reading of the term plaintiffs to include the customers and members whose interests Plaintiffs' Maximum Defense and Firearms Policy Coalition have represented since day one of this litigation is correct. The court goes on, that reading is correct. Also, as requested, the term plaintiffs in this case includes the individual plaintiffs' resident family members. Any relief beyond what is explicitly requested, which arguably would be tantamount to a nationwide injunction, is denied. So, the clarification, unfortunately, is not much better. It is better, but it's still not the clarification that we had hoped for. Because what does it mean by members whose interests Plaintiffs' Maximum Defense and Firearms Policy Coalition have represented since day one of this litigation? Does that mean you had to be a member of Firearms Policy Coalition the day the case started? Or does it apply to current members, even if you joined after the injunction? Or did you have to join by the time the injunction was entered? Those things aren't clear. The other thing that's not clear is whether Firearms Policy Coalition members outside of the Fifth Circuit are covered or protected by this injunction. Firearms Policy Coalition seems to believe that it does. They're reading this in the broadest sense, and that means that it applies to members even if they joined after the injunction was granted, and members who live outside of the Fifth Circuit. The narrowest interpretation of this order is that it only applies to Firearms Policy Coalition members who were members when the case was filed, and only those members that live within the Fifth Circuit. I wish I could provide you a clear answer on this, but it's going to come down to some degree what your risk tolerance is in terms of whether or not you want to interpret it in the broad sense or the narrow sense. I think ultimately the Firearms Policy Coalition is probably right, but it doesn't mean that the federal government and the ATF are reading this injunction in the same way, and that you wouldn't get arrested potentially and have to prove that you are in fact a member and that this injunction applies to you. So the safest or the most certain is that if you are a member at the time the case was filed and you live in the Fifth Circuit, I think you're almost certainly protected. Beyond that, it's less clear. Now, this is in the Firearms Policy Coalition case. With respect to the Second Amendment Foundation case and the Gun Owners of America case, those cases were in federal district courts, which are the trial court level courts in the Fifth Circuit. And the courts in those cases, after the mock injunction was entered, also entered injunctions. Again, somewhat ambiguous. I think the Second Amendment Foundation injunction was the least ambiguous and the most open to interpretation in the broad sense. The Gun Owners of America injunction, unfortunately, had language in there about current members, and it's not clear what the judge meant by current members. Again, was it members that were members at the time the injunction was entered, or does it also apply to members who joined after the injunction was entered? And then, of course, there's the problem of scope. Does it apply to members who live outside of the respective districts in those cases? I think it probably does, but once again, it's not clear, and I can't give you an answer for certain in this regard. Now, lots of attorneys have opined on this issue and lots of disagreement, but I think, again, like Firearms Policy Coalition, the Second Amendment Foundation, and Gun Owners of America are interpreting these injunctions in the broad sense, which means that they believe they apply to members who joined even after the injunction was filed and members who live outside of the Fifth Circuit Court of Appeals jurisdiction. Of course, if you don't feel comfortable that these injunctions apply to you or protect you against the enforcement of the ATF Final Rule on pistol stabilizing braces, you still have the option or options that the ATF laid out in the Final Rule. Of course, the amnesty period is over, and if you haven't complied with one of the options to this point since June 1st, you would be a felon in the eyes of the federal government and the ATF. So you can destroy the firearm, you can turn it into the local ATF office, you can put a barrel on the firearm that is longer than 16 inches, you can remove the brace from the firearm and destroy it or alter it so it cannot be reattached. So you still have those options if you're concerned that the injunctions that have been entered so far, the 3 injunctions in the GOA case, the SAF case, and the FPC case, may not apply to you. Now, what some attorneys are recommending is that you simply remove the brace. I'm not comfortable that that complies with the ATF Final Rule. I'm not comfortable in giving that advice. If you think that that is good enough for you, I think there are some attorneys out there who would support that notion or decision. And certainly, I think there's a colorable argument to defend that. But again, doesn't mean you wouldn't get arrested and would have to defend it. So those are considerations. You just have to make a choice with respect to what your risk tolerance is and what you want to do. Of course, as an attorney, I can't tell you not to comply, but I know that lots of people are probably not complying. And we actually got some numbers that the Reload reported just a few days ago, or actually it may have been yesterday that it was reported, or maybe Friday. I can't remember which. But they reported that approximately 250,000 people registered their firearms equipped with pistol stabilizing braces during the amnesty period, which is a very low percentage. The estimates are that there are between 3 and 40 million of these particular items out there, these firearms equipped with pistol stabilizing braces. So 250,000 is a very low compliance rate. And I suspect most people are either don't know about it or are availing themselves of one of these other options, which I think is great. I think this is a totally unconstitutional rule. I think the ATF has overstepped its rulemaking authority. I think it's overstepped its administrative authority. It's violated the Administrative Procedures Act. It's violated the Constitution. And it's completely stepped outside the bounds of its authority. So I'm optimistic that the final rule will ultimately be overturned and struck down by the courts. The Fifth Circuit is set to hear oral argument in the Mock v. Garland case, which is the Firearms Policy Coalition case, on June 29th. So in just a few weeks, they're set to hear oral argument in that case, and I think will issue a decision shortly thereafter. And I think we're going to get some good news out of that. But in the meantime, if you're not covered by the injunction or not comfortable in thinking that you're covered by the injunction, you'll have to avail yourselves of one of the other options provided by the ATF or risk being considered a felon. I'll link to the previous episodes where we talked and covered these options in more detail and talked about the injunctions and the arguments prior to the end of the amnesty period. So if you're interested in going back and listening to those, I'd certainly encourage you to do that. But I just wanted to provide you a quick update about where we stand. The good news is, like I said, we've got 3 injunctions, which means 3 courts believe that the plaintiffs challenging the ATF here are substantially likely to prevail on the merits of the case, and that without entering this injunction, without stopping the enforcement of this rule against the plaintiffs, there would be irreparable harm. So that's great news. I think the ATF will be defeated ultimately. But in the meantime, we wanted to let you know what your options were. So thanks everybody for tuning in. Hope you enjoyed it. If you did, as always, don't forget to like and subscribe to help us spread the message of freedom. Announced this in the previous episode that I'll be talking with Donald Rainwater, Libertarian candidate for governor here in Indiana, later this week. And I'll be releasing that conversation on Sunday. I hope you'll tune in for that. I think he's got a lot of really interesting ideas for Indiana that I think are also applicable and of interest to people nationwide. So please tune in for that. Thanks for tuning in today. And until then, remember, you are the Forge of Freedom.